is Ms.Debora. I am from Commerce Department. Today I am going to talk about contract of sale, which will come under Sale of Goods Act. As you all are already aware about Indian Contract Act, so now we will be talking about contract of sale, which falls under Sale of Goods Act. Now, Sale of Goods Act was earlier included under Chapter 7 of Indian Contract Act. But later, Sale of Goods Act, it was separated from Indian Contract Act, and a separate act was formed in the year 1930 known as Sale of Goods Act. So now we are going to talk about the topic contract of sale. Now, contract of sale, the definition goes like this as per section 4(1) of Sale of Goods Act. It is a contract whereby the seller transfers or agrees to transfer the ownership in goods to the buyer at a price. Now the question comes when the buyer will become the owner. Is it the buyer will become the owner immediately, or whether the buyer will become the owner at a later date? Now we need to know the meaning of two important words, that is definition of sale and definition of agreement to sell. Sale means where the buyer will become the owner immediately. And the best example for this is the cash sales. The other name, I mean to say, the sale is also known as absolute sale. Now the second important term what we should know is agreement to sell. Agreement to sell means where the buyer will become the owner at a later date or time or subject to certain conditions to be fulfilled thereafter. Now this definition is given under section 4(2). Now, coming to the features of contract of sale, the first feature of contract of sale is two distinct parties. Here, the meaning of the word distinct means separate. It means for a contract of sale, there should be two different parties. The two different parties are buyer and seller. According to section 2(1), buyer is a person who buys or agrees to sell the goods. And according to section 2(7), seller is a person who sells or agrees to sell the goods. Now, at this point, we'll take one case, that is State of Gujarat versus Raman Lal and firm. In this case, what happened was a partnership firm was dissolved and surplus assets were shared among the partners. Now, a question was raised by the government whether this sharing of assets, can you call it as a sale or not? Now, in this case, it was given a judgment that as per the rule given, partners and partnership firm are one and the same, and as per the rule, we should have two separate parties. So in this case, it was declared that it is not sale, I mean to say it's only distribution of assets. Now coming to the second feature of contract of sale, that is contract of sale can be either absolute or conditional. As I already said, sale means where the buyer will become the owner immediately, and agreement to sell means where the buyer will become the owner at a later time subject to certain conditions to be fulfilled thereafter. Now coming to the third feature of contract of sale, that is contract of sale can be either express or implied. It means contract of sale can be entered into either by words spoken or written, which is express, or it can be assumed from the circumstances or conduct or behavior or the course of dealings between the parties. Now coming to the next feature of contract of sale, that is it should possess all the features of a valid contract. Now the features of valid contract, which is already covered in our unit 1, that is the contract should have offer and acceptance, intention to enter into legal relationship, consideration, free consent, capacity, possibility of performance, certainty of meaning, and it should fulfill all the legal formalities. Now coming to the next feature of contract of sale, that is there should be transfer of general ownership and not special property. Here general ownership means where buyer has become the owner, so that seller is no more the owner of the goods. Now let us understand the meaning of the word special property. I mean to say, suppose if a person wants to take a loan, and if that person keeps a movable item like a gold or anything as security and takes a loan, then the person who has given the loan will only have a special right on the things. I mean to say, it will not become the owner, will only have a special right on the things. I mean to say, later suppose if the person is not repaying the loan, then the person who has given the loan has a right to sell off. So will not become the owner, only thing is he will only have a special right on the goods. Now coming to the next feature of contract of sale, that is the price. Now the consideration for contract of sale, which is called as price, must be money. Now remember, the price can be paid totally in cash or partly in cash or partly in kind, but price cannot be paid totally in kind. The reason is, when goods are exchanged for goods, it is known as barter system and it is not sale. Now coming to the last feature of contract of sale, that is goods. Now goods, as per section 2(7) of Sale of Goods Act, the definition goes like this. Goods means only movable things. Now the term goods also includes stock, shares, growing crops, trees, or things attached to or forming part of land which can be severed before or under contract of sale. Now the most important thing what you have to remember is goods does not include three things. The three things are money, immovable property and actionable claims. Now actionable claims means the suit which can be recovered in the court of law. The best example for this is negotiable instrument, like I mean to say the other forms of money like check or a promissory note or a bills of exchange. Now coming to the types of goods, now basically goods are classified into three types, that is existing goods, we have future goods and again you have contingent goods. Under existing goods, we have specific goods, ascertained goods and unascertained goods. Now coming to the existing goods, now existing goods are those goods which are owned and possessed by the seller at the time of contract of sale. Now coming to the meaning of specific goods. Specific goods are those goods which are identified or specified at the time of contract of sale. Now coming to ascertained goods. Now ascertained goods are those goods now which are identified subsequent to the formation of contract of sale. I mean to say when the selected goods are kept aside, marked, packed and kept ready for delivery, these goods will become ascertained goods. Now unascertained goods are those goods which are not specified or identified at the time of contract of sale. Now coming to the future goods are those goods which the seller do not possess at the time of entering into contract, but the goods will be produced or acquired or manufactured by the seller depending upon the requirement. The best example for future goods is placing an order for making of furniture or placing an order for making of, I mean to say, gold ornaments, etc. Now coming to the contingent goods. Contingent goods are those goods the sale of which depends upon happening or not happening of uncertain event in future. Now the best example for this is, suppose A and B enter into contract where A tells to B, I will sell you 100 bags of rice to B if there are good rains. Now the contract between A and B will be fulfilled only when there are good rains. I mean to say the contract is dependent on the good rains which may come or may not come. So with this, I have covered the introduction to Sale of Goods Act. We have covered the meaning of contract of sale. I mean to say the two important definitions I covered, that is definition of sale, definition of agreement to sell and the features of contract of sale. Along with that, I also covered the types of goods. Yes, thank you.